career pardon attorney. I declined to rubber stamp a political favor for a friend of the president, and it cost me my job. Mr. Blanche's office had asked me to recommend restoring the gun ownership rights of a convicted domestic abuser. I raised concerns about public safety, but Mr. Blanche's staff pressured me to go along anyway. I did not. Domestic violence is the leading type of homicide among women. When a domestic abuser is armed, his victim is 5 times more likely to be killed. But because this particular domestic abuser had a personal relationship with the president, Mr. Blanche's staff asked me to set aside my concerns. When I wouldn't, Mr. Blanche fired me within hours. He then took extraordinary measures to silence me. He sent U.S. Marshals to my home in an effort to prevent me from speaking with members of Congress. I was shocked to hear Mr. Blanche's testimony about this yesterday. What he said about my firing is provably false. His claim that it had nothing to do with the concerns I raised is contradicted by documents and evidence. His claim that he tried to call me before sending marshals to my home is flat out false. His claim that it is normal for DOJ to use armed law enforcement officers to deliver mail to the homes of its former employees is preposterous. The casual lies that Mr. Blanche tells, even while sitting in this chair testifying to this committee, are emblematic of a much larger problem. Courts across the country have said they can no longer trust the Justice Department to uphold the law and tell the truth. There are over 700 documented instances of DOJ violating judicial orders. There are nearly 100 cases in which judges appointed by both parties have found that DOJ presented false or misleading information in court. Earlier this week, a federal judge found that Mr. Blanche personally misled this Congress about the department's settlement agreement with President Trump. To the American public, it looks like Mr. Blanche is running DOJ as Donald Trump's personal law firm. He is using law enforcement powers to pursue petty grudges harbored by the president. These pointless vendettas are wasting our scarce resources and destroying DOJ's credibility. Mr. Blanche has repeatedly placed President Trump's interests ahead of the interests of the country. The collusive settlement agreement is a perfect example. It protects the entire Trump family and all of their businesses from any investigation or audit forever. It gives away nearly $2 billion of our money for no reason at all. It is a windfall for the president and his allies at the expense of the American people. A court found that signing this agreement was a betrayal of Mr. Blanche's duty to zealously represent the interests of the United States. That is the most basic obligation of the Attorney General. Mr. Blanche said yesterday that the settlement fund is dead. It is not. That is Contract Law 101. Mr. Trump or his sons could seek to enforce it at any time. Mr. Blanche gave bizarre excuses for not meeting with Jeffrey Epstein's victims. Yet he spent 2 days personally eliciting testimony from Ghislaine Maxwell, Epstein's partner in crime. After this imprisoned sex trafficker made statements claiming to exonerate the president, she was moved to a minimum security camp. That is a grievous breach of DOJ policy. It is an abuse of Mr. Blanche's office. It is a terrible betrayal of Epstein and Maxwell's victims. Mr. Blanche's callous approach to the Epstein case matches his cavalier attitude toward rearming domestic abusers. At the end of the day, the priority of this DOJ is protecting powerful men, even when it comes at the expense of vulnerable women. What Mr. Blanche is doing is dangerous. Earlier this week, 2 Supreme Court justices sat here and testified about the terrifying threats that judges are facing in this country. Meanwhile, Mr. Blanche is fueling those threats by attacking judges who rule against the administration and declaring a war against the courts. These are not partisan concerns. Americans across the political spectrum rely on DOJ to keep us safe and free. Mr. Blanche has shown that he is willing to put all of that at risk to serve a political agenda. I beg the members of this committee to think about what this is costing our country. Please do not degrade our justice system further by promoting Mr. Blanche.
Oyer held the post of career pardon attorney, a position that required independent judgment rather than political convenience. Blanche's office asked her to recommend restoring firearm rights to Mel Gibson, an actor and known supporter of the president. Gibson had lost those rights after a 2011 misdemeanor domestic violence conviction. Court records from that case describe an incident in which he struck his then-girlfriend while she held their infant, punched her in the mouth hard enough to break teeth, and made threats that involved a firearm. Federal law prohibits people with such convictions from owning guns for a reason the statistics make plain. Domestic violence remains the leading form of homicide among women, and the presence of a firearm multiplies the risk that a victim will be killed by 5 times. Oyer put those concerns in writing. Staff from the Deputy Attorney General's office pressed her to set them aside. She refused. Within hours, she was removed from the job she had held after more than 13 years of federal service. That firing alone would have been enough to draw attention, but Oyer told the committee the response went further. Armed United States Marshals arrived at her home. She stated the purpose was to keep her from speaking with members of Congress. When Blanche addressed the same events the day before her testimony, he offered a different version. He said the dismissal had nothing to do with the safety concerns she raised. He said he had tried to call her first. He said using marshals to deliver paperwork to former employees was normal. Oyer answered each point in turn. She said the first claim was contradicted by the timeline and the documents. She said the second claim was simply false. She said the third claim was preposterous. The committee was left with 2 accounts that could not both be true, and the distance between them became one of the most closely watched moments of the entire hearing. The story did not remain limited to one personnel decision. Oyer described a department that had already begun losing the trust of the courts. Legal trackers had recorded more than 700 instances in which the Justice Department under Blanche's leadership violated judicial orders, whether through neglect or deliberate choice. Nearly 100 separate cases involved judges appointed by presidents of both parties finding that department lawyers had presented false or misleading information in court. Career attorneys were leaving in large numbers. Reports indicated the department had lost more than a quarter of its lawyers. Those who remained described morale as the lowest many had experienced. Safeguards that once limited political interference were being removed, Oyer said, creating an atmosphere in which honest advice carried the risk of sudden removal. The settlement that followed drew some of the strongest language from a bench. In the spring of 2026, the department resolved a $10 billion lawsuit the president had filed against the IRS over the leak of tax returns. Blanche personally signed an addendum that established a nearly $1.8 billion fund presented as compensation for people who claimed they had been targeted by prior administrations. He later told Congress the fund was dead. Contract experts and a reviewing judge noted that the underlying agreement remained enforceable. More consequential was the permanent language that barred the United States from pursuing any claims, audits, or investigations against the president, his sons, their families, and their businesses for returns filed before the settlement date. A federal judge described the arrangement as a blanket grant of immunity and a betrayal of the department's duty to represent the interests of the United States. Groups of retired judges from both parties filed statements alleging that the department had misled the court about whether a settlement even existed. Oyer told the senators the deal protected the powerful while the public received nothing in return. The same pattern, she argued, appeared in the handling of the Epstein case. In July of 2025, Blanche spent 2 full days personally interviewing Ghislaine Maxwell, the the woman serving a 20-year sentence for her role in trafficking underage girls with Jeffrey Epstein. Released transcripts show Maxwell offering statements that describe the president in favorable terms. Approximately 1 week later, Maxwell was transferred from a low-security facility in Florida to a minimum-security prison camp in Texas. Long-standing Bureau of Prisons policy generally keeps individuals convicted of sex offenses out of such camps. Blanche later said the move responded to threats against her. Survivors and their representatives called the transfer preferential treatment and a clear breach of the rules designed to protect the public. When Blanche finally met with some of the victims under pressure connected to his confirmation, several described the conversation as abrasive and non-committal. Oyer placed the contrast in plain view. Extended time spent with the convicted trafficker. Limited, and by the survivor's account, dismissive time given to the people who had been harmed. She said the priority was unmistakable. Throughout her appearance, Oyer returned to a single idea. The Justice Department exists to keep the country safe and free, not to settle private scores or shield allies. She listed the court findings, the mass departure of experienced lawyers, the permanent protections written into the tax agreement, and the prison transfer that followed the Maxwell interviews. None of these, she insisted, stood alone. Together, they formed a pattern that courts themselves have begun to describe as the loss of the presumption of regularity, the long-standing assumption that government lawyers act in good faith. Once that presumption erodes, restoring it is difficult. She closed by asking the committee to weigh the larger cost. Americans across the political spectrum depend on a Justice Department that follows the law rather than personal loyalty. Confirming someone who, in her account, had already shown willingness to place one man's interests above that duty would further weaken the institution. The room remained quiet when she finished. The reaction that began the moment she started speaking continued long after the hearing ended. People who expected routine confirmation theater found themselves listening to a career official describe the personal price of refusing an order she believed